Hi, I'm Christopher Cavalli of Callagy Law in Paramus, New Jersey. I'm a partner in the Family Law Department. In cases involving domestic violence, it is very likely that the defendant's weapons will be seized and forfeited. Those cases involve instances where the defendant is arrested for domestic violence, is convicted of a misdemeanor crime of domestic violence, or has a domestic violence restraining order issued against him or her. In those cases, most likely the victim will alert the police that the defendant has a weapon. The defendant may also be asked if they have any weapons. When the police go to the defendant's home to either arrest the defendant or inquire about the domestic violence charge, they are given broad discretion to search the home for the weapons, if not just turned over by the defendant. Once the weapons are seized, it is, in most cases, unlikely that the weapons are going to be returned. However, if they will be returned unless a domestic violence restraining order is issued, a crime involving the weapons occurred, or the court finds that there's another reason to keep the weapons away from the defendant. The prosecutor, in this case, has, once the weapons are seized, the prosecutor has 45 days to determine whether or not they're going to give the weapons back to the defendant. And these weapons can include anything from hunting rifles and shotguns to handguns, to even BB guns and pellet guns, even antique guns that may not even work, and in some cases even some type of antique swords and knives. Any weapon that could be used to hurt or kill someone is basically considered a weapon and will be seized in these cases involving domestic violence. Again, unless a restraining order or a crime has been committed, restraining order has been issued, or a crime is committed, or there's other reason, the prosecutor should return the weapons to the defendant, who shouldn't even be a defendant anymore. So in some cases they are returned, but in a lot of cases they're not, especially in the event of when a restraining order is issued. And then at that time, again, the prosecutor has 45 days to decide whether to give them back to the defendant, and if not, then the defendant has 60 days to arrange for a transfer or a sale of the weapons. So the biggest lesson that we have to learn from this is, if you are a defendant and you have been accused of domestic violence and there is a restraining order hearing, and there's a temporary restraining order issued against you, it is important to protect yourself and not let the final restraining order be issued against you. We see a lot of cases where defendants don't even fight the restraining order. They don't contest the restraining order. They just literally say okay to the issuance of a restraining order against them, thinking it's no big deal. But as we've talked about before, it is a big deal, because a violation, or even an allegation of a violation of a restraining order, also has pretty severe consequences. This affects avid hunters and people who are just law-abiding gun owners. We see a lot of times that people who are in relationships that break up, sometimes they are falsely accused of domestic violence and should not by any means have a restraining order entered against them. But if they don't contest it, or they don't protect themselves from having a restraining order against them, then their weapons will be seized. So it is important that if you've been accused of domestic violence and there's a restraining order hearing, that you seek an attorney who is knowledgeable and experienced in the realm of domestic violence and restraining orders. I have been practicing exclusively family law for 23 years. I am certified by the New Jersey Supreme Court as a matrimonial law attorney, and I've represented hundreds of victims and defendants in domestic violence cases. So if you are in the need of any counseling or would like any advice on restraining orders, especially if one is pending against you, or if there is one against you and your weapons have been seized, please contact me, 201-261-1700. Again, Chris Cavalli, Callagy Law. Thank you.